go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
All right. Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, a networking platform, meeting ground, and community where professionals, employers, and licensed immigration attorneys come together to learn, exchange information, and stay updated on U.S. immigration developments. My name is Nikola Ristic, your host, and I'm excited to bring you today's session, From Temporary Visa to Green Card, Long-Term Immigration Planning for Business Professionals. For many business professionals, securing a temporary U.S. work visa is only the first step. The greater challenge is building a long-term immigration plan that supports career growth while aligning with employer needs and evolving immigration standards. With shifting policies, complex timelines, and role-specific requirements, planning is critical to maintaining stability and avoiding disruptions. Today's session is designed to help professionals understand how long-term immigration planning works in practice, how temporary visas connect to employment-based green card pathways, and what considerations matter most when planning for the future. To guide us through this critical discussion, we're joined by attorney Alka Bahal. She's a New Jersey-based immigration attorney known for her work in corporate and business immigration. Her practice focuses on helping companies navigate visa sponsorship and workforce planning, and on assisting professionals pursuing work visas and employment-based green cards with clarity and foresight. Attorney Bahal, thank you so much for joining us today. We're delighted to have you here.
Thank you for having me. It's an honor.
Just before we begin, a quick note for everyone tuning in. ImmigrationQuestion.com is a public platform catering to both attorneys and people with immigration questions. Attorneys who participate do so independently, and the platform does not provide individualized guidance. To everyone joining us from Facebook, YouTube, LinkedIn, and any of our other platforms, welcome. If you haven't subscribed yet, now's a great time. Grab your notepads. Let's get started. Attorney Bahal, many business professionals enter the U.S. on temporary visas. What early planning steps should individuals take to keep future green card possibilities open from the very beginning?
A couple of different things, Nicola. Number one wants to make sure that at all times you are in compliance with your non-immigrant visa, whether that's a B1, B2 visa, H1, or an F1 student visa. So it behooves you to understand the rules, requirements, and limitations of the visa you'll be here on to make sure that there are no accidental overstays or missteps that can impact your ability to get permanent residency in the long term. And then, of course, if your plan is to become a permanent resident in the long term, you want to understand how that works and interrelates with the non-immigrant visa that you're on. In some cases, you can pursue those concurrently, such as if you're on an H-1B and you have an employer sponsor you. And in other cases, you may not be able to, or it may be tricky to pursue them concurrently, such as if you come in on a student visa and then you marry a U.S. citizen and you seek to adjust your status. There can be some incompatibility in regards to intent there. So really understanding, what you're allowed to do now and what you plan to do in the future and how you execute it, those are the real main elements you want to be able to preserve your ability to become permanent resident.
So it's a case of understanding what your specific allowances, your specific permissions are, and then understanding that as things change, your plan may change accordingly. But the biggest thing there is just making sure that you're doing everything as you should to prevent any speed bumps in the future or down the line.
Well said, yes.
All right, amazing. So another question I'd love to ask you is that common temporary visa categories are often tied closely to specific roles or employers. How do these specific visa types influence long-term green card planning and overall strategy?
So I wouldn't say necessarily any particular non-immigrant visa does or doesn't marry you, if you will, to a specific green card process. The way it works is the non-immigrant visa is really a separate but parallel track to the immigrant visa. So, although there are certain sort of sets of applications that tend to go hand in hand, for example, a person who comes on the H-1B is most often going to get permanent residency via labor certification. So they go hand in hand, but not required. If somehow that individual would qualify for an EB-1A, there's certainly no reason why that individual couldn't apply for it, even though they've held an H-1 and maybe not an O-1 in the past. So not necessarily required to be tied together, just often paired together. Similarly, a common pairing would be an L-1A visa, where someone's come in as an intercompany transferee. That person is really going to be the only type of individual who can qualify for a priority worker. It also requires you have worked for the foreign employer and have transferred to the U.S. and then has some different requirements around it. Typically, as an H-1B employee, you haven't worked for the foreign affiliate, and so you're simply not going to qualify for that type of green card petition. So again, in terms of planning for your permanent residency, you want to know what's out there and available to you. So if you've worked for a foreign entity before and you're moved to the US, there may be things available to you. Whereas if you've never worked for a US company in the past. So it's really all about building the best case that you can to get there, regardless of whatever non-immigrant visa you're here on at this time.
So just to make sure that I got it correctly here, while there are pairs that will work together and let's say pathways that people are more likely to walk, just because you started out in a specific way doesn't mean that's the way you're going to finish it. Your specific circumstances are going to determine what's best for you, regardless of the visa that you came in on initially.
Correct.
Okay, beautiful. The next thing I'd like to ask you is about timing. So timing, as we both know, can play a significant role in outcomes. When should professionals begin thinking about transitioning from temporary status to permanent residence? And what risks should people be aware of when planning starts too late?
Absolutely. So again, I think it really comes down to understanding what your options are and how each process works. So as I mentioned previously, there are some sort of pairs of processing that are incompatible. If you're here on a student visa, you are presumed to have non-immigrant intent. And if you pursue permanent residency and reach a certain phase of it, for example, you marry a U.S. citizen, file for adjustment of status, that is declaring an opposite intent. That's declaring an intent to reside permanently. So one can begin the planning and the strategy at any point, and sooner, in my opinion, is always later in terms of planning and goal setting, as well as understanding how you might qualify now or might need to work on your credentials to make qualify in the future. And then again, keeping track of your current visa requirements. Are there time limits that you need to be aware of in terms of your permanent residency process? Specifically for an H-1B applicant, you are limited to being physically present in the US for a maximum of 6 years in H-1B status. That combines previous time in H-1B or L-1 status. In order to stay past that point, which many individuals really need because it takes so long to become a permanent resident, you have to meet certain milestones, including having your employer file things for you, file certain timelines and deadlines. Some of those applications, such as a perm labor certification, can take a long, long time to prepare and file, sometimes a year. So a lot of the strategy and planning needs to come well in advance. So, for example, even if you want to file your file your perm labor certification before you hit your 5th year anniversary in H-1B status, my firm, we typically recommend you initiate that process at least by anniversary year 4. So you have at least a year to prepare and file that application. So doing it earlier than that is certainly not a problem. Now you need to balance this legal requirements, timing, and those pressures with business requirements, right? It can be difficult just joining an employer and suddenly saying, I need labor certification to be filed immediately. This is a time and cost intensive process. The employer has to bear a lot of those costs. So my advice is always to be upfront and transparent If you know you're going into a new employment situation and you know you're going to be looking for permanent residency, I'd recommend negotiating that as part of your employment package. Certainly nothing wrong with it. You're not asking for anything difficult or insurmountable, but I always recommend that everybody's walking into things with eyes open and pre-planned. It really makes everything go more smoothly. And again, strategy and looking forward, planning and making sure we're reaching milestones is really important for foreign nationals.
So what I'm hearing is give yourself as much time as possible. You really can't rush some of these things.
No, yeah. I mean, we're stuck with as long as it takes is as long as it takes. There's sometimes just nothing we can do about it.
Absolutely. So let's talk a little bit about individuals who have these jobs already. So we know that career growth is rarely static. You switch around, you get new positions, you get new titles. How do these promotions, role changes, shifts in job duties affect your long-term immigration planning and the green card pathways that you have access to?
So it's sort of an interesting dynamic that being successful in your career and moving up the ladder can actually adversely affect your immigration planning, all depending on how far afield you move from your original position and the timing that it takes for your permanent residency process to move. So for example, if you are a Belgian national and you have filed for labor certification as a software engineer, we're moving through the process, we're at the last stage and we're filing for your adjustment of status. It's been 3 years and you are now a senior software engineer. I would view that as substantially similar to the original position, similar, if not almost identical duties, just at a more senior level. And so I wouldn't say that that would necessarily adversely affect your petition. That same application for an Indian national who is not going to be in a position to file their adjustment of status for maybe 10 to 12 years after the labor certification has been filed and approved is looking at a much longer career projection. At that point, they might be the head of engineering and software development, which then is in my opinion, a substantially different job than the original software engineering position that had been filed. And so because the requirement is that you are employed in the position for which you're sponsored in your labor certification, in that sort of a situation, we then recommend a second labor certification that's completed for the new position. And in some cases, we are beginning to really look at career progression and planning, and we're filing for the next position as opposed to filing for the position that you're in when we know that this is going to become an issue. Of course, there's some risk involved there. If you don't get the promotions and you don't perform as expected, it can be a little bit of a challenge, but knock on wood, so far we haven't had anybody that's had an issue. But if you don't plan ahead and if there's, sort of this timing issue, when the individual is moved into that new position that is significantly different, we would do a new labor certification and a new I-140 and have that in place. The good news is it doesn't change your priority date. The person can keep their original place in line where they're waiting to get their permanent residency. And we're instead just swapping in a new labor certification that now declares a new position and the new I-140 that shows how the person qualifies and that the company continues to sponsor it. So in many cases, like for an Indian national who is waiting, 12 years, there's plenty of time to do this without interrupting the overall timeline.
Absolutely. So sorry, really. All that to say, you just need to keep your lawyer in the loop. You want to be on top of everything, and sort of back to our earlier point, the sooner you start planning, the sooner you lay out your overall strategy, the more you can do to mitigate the effects of any of these adjustments that you'll have to do to your application, given that the material facts are changing here.
Correct.
Okay. And sort of in line with that sort of concept of planning and some of these longer timeframes, I like to talk about documentation. So the documentation, it builds up over time. What record-keeping habits should professionals maintain to support future employment-based filings?
Absolutely. A really great question, and one that I think not enough foreign nationals ask. So first and foremost, of course, keep a record of all your passports, old, doesn't matter. If you are from a country which requires you to turn in your passports when you obtain a new one, keep a nice, clear color copy of all your prior passports and keep them in a safe place. Second, all the visa documentation that you get over the years related to any and all the visas you keep. It doesn't matter if you were here as a student 12 years ago and you're not looking to apply for permanent residency until 2 years from now, we still need all that documentation. And although it doesn't necessarily seem intuitive that things that are 10 or 12 years old can matter today, they can. And in fact, as they become older, it can be more difficult to replicate those documents. So if we're unable to prove, for example, how you first entered the country and that you did so lawfully, if it was 20 years ago, there's going to be a problem with your ability to adjust status. So keep copies safely of all your immigration documentation, all previous I-20s, visa stamps, all I-94 cards issued to you, any approval notices, denial notices, requests for evidence, etc. Next, I would recommend, as a good habit, all foreign nationals track their entries and exits to the US. So I generally recommend people keep an Excel sheet and mark all dates of exit and entry so that you have a log of all the time that you came in and out of the US. So we know how long were you here as a student? How long were you here as a visitor? How long were you here as an H-1B visa holder? For some of those categories, it can be really critical to be able to prove the dates that you've been here in order to show your eligibility for a visa. For example, we want to know how long you were here on a B1, B2 visa as a visitor. The government may question your intention during that time. Were you really here as a visitor? And if they claim you were in the US for 6 months, 180 days, as a visitor, and they're using that as proof that you didn't comply with the visa and you really were working for the employer who's now sponsoring you, for example, and you have records that show maybe you flew in and out over a 6-month period, but you were only actually in the US for 40 days, we would want to show that information. So having those records is important. Similarly for an H-1B, knowing the dates that you were here can be really critical. As you're approaching your 6th year, if we want to be able to demonstrate you really only spent 5 years physically present in the US, and here's all the dates, and here's all the data to back it up, then the government's going to grant you that additional year. Whereas if we can't prove anything, then we're going to have to accept the proposition that you were already here for the 6 years. So keeping those records, again, keeping clear copies of all your passports, which may no longer have all the stamps of entry and exit. Nowadays, they no longer stamp you all the time when you enter the US. In the old days, we could actually get a copy of a passport and hunt up all the stamps and figure out the days of exit and entry. That's no longer the case. Many countries are moving either to inkless processing. So there's no record if you don't keep it. So that would be a really important thing to do. Additionally, I think it kind of goes without saying, but I'll say it anyway, all your educational records, your school records, anything of that nature that goes to your fundamental qualifications, certifications, accolades, those sorts of things, keep a folder and keep track of all those things. Licensure, anything that's obviously necessary in your profession, very important. What else in terms of record keeping? I really think that covers most everything.
And I think the thing that's really interesting about what you just said is that it really ties into your statements earlier about how much of a long-term process this is, how much strategy, how much thinking goes into it. The second you start thinking about immigration, you probably want to start collecting these documents. You probably want to start talking to whoever it is you need to talk to start putting these things in motion. But over those years, if you're able to do this, it should make things as easy as possible for yourself and for your representation to get you the outcome that you need.
Absolutely.
And now, with all of that said, I'd love to ask you about the future a little bit. And with that, looking ahead, what broader strategic considerations should professionals keep in mind as immigration standards, business needs, and career goals continue to evolve?
Good question. This kind of ties into what we were talking about earlier with, things changing, evolving at a very rapid pace in the immigration arena in the U.S. I think it makes it difficult to plan. It makes strategy difficult to pin down. because we make all the plans that we can based on what we know today, and we have to be prepared for the fact that it could change 6 months from now. So I think that that is an important factor, kind of a new element that has been introduced over the last year into long-term immigration planning, which is, we can do our best, and we do need to keep up with all the changes. And every time there is a substantial change, we have to kind of look at our plan again, look at our strategy and see, does it affect us? And if it does, how does it affect us? How do we need to pivot to accommodate for the new pathway? In many cases, maybe it won't affect us. It could be a tangential change. For example, if someone's in an employment situation, they're on an H-1B looking for permanent residency through labor certification, we've seen significant changes in the asylum arena, in a temporary protected status, in travel ban countries. And if none of those things directly affect the employee's not born or a citizen of any of those travel ban countries, no relationship to asylum, no need for TPS, then those things are happening, but they don't necessarily affect our strategy. Other issues such as, are we a student looking to get an H-1B visa under the cap in the upcoming fiscal year? There are new changes that do affect us directly, including the change to how they will do the H-1B lottery this year. It's no longer a random lottery. It's going to now be a weighted lottery related to the band in which your prospective salary will fall. That has larger implications, not just for the foreign national and how many times they might be entered in the lottery, but to employers, especially to smaller employers who aren't necessarily paying top dollar, for qualified candidates. Not every H-1B, person who's looking for an H-1B is going to be able to work at a huge firm with, deep pockets. They may be looking to work for a smaller company that really values their work and gives them more opportunity to do different things, but maybe doesn't have the salary that is, at a bigger organization. So again, a lot of things that's going to go into the strategy.
So as we know, you can't really predict the future, but staying aware of updates, understanding what it is that affects you, and honestly, just continuing to plan, keeping that documentation, and just doing the best you can. You can't control the changes, so just stay aware of them.
That's correct.
All right. So for everyone joining us live, long-term immigration planning is most effective when it aligns professional growth with thoughtful preparation and awareness of how employment-based pathways are evaluated. Staying informed early can make a meaningful difference. This is your first time tuning in? Welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration-related questions at no cost and engage directly with participating attorneys. We're also proud to share that ImmigrationQuestion.com is Better Business Bureau accredited and ISO certified, reflecting our commitment to transparency, accountability, community education, and security. Attorney Bahal, based on your experience, how do platforms like ImmigrationQuestion.com help immigrants and immigration attorneys like yourself?
I think that goes to the core of the issue, which is to understand the law, the trends, the policies that might affect foreign nationals, their employment, and their immigration strategy, which is, as the theme of our show today, is the most important, thread for foreign nationals to kind of keep track of.
Thanks for that. We really love to hear that both immigrants and immigration attorneys get value from it. And before we move into our live Q&A, I got one final question for you. Attorney Bahal, for business professionals who want to stay flexible while planning for permanent residence, what mindset or approach is really best to help navigate long-term immigration planning more effectively?
Very good question. So I think one has to be prepared these days for the variances in the ebb and flow of immigration. As we discussed, I think you have to kind of stay ahead of things, plan and file quickly, early, effectively, but to have the mindset where you're going to, sit on top of immigration and call them and ask them questions and try to push your case along ahead of others is really not going to be a strategy that's going to work out well, either for your mental health or for your actual application. As USCIS or Department of State or whoever it is that's adjudicating it starts to see all those inquiries paying up, it tends to have a negative effect on your application. So to kind of be aware and be proactive, but to try and not get nervous and wrapped up in it. It is a little bit of the way it's going to go, once it's in the government's hands. There's got to be a little bit of hands off. We have to let them, do what they need to do. And that's not to say we're never going to follow up with them or we're never going to try and hold them accountable. But we do want to kind of listen to what are they reporting in terms of their processing times? What sorts of factors are going on that are going to impact whether they could be adjudicating your type of case? So for example, when the H-1B season starts, right, we'll have our registration starting in March. We'll have H-1B cap cases filing in April. And that will be a lot of cases that will be inundated into USCIS. You have to kind of understand that it is still a government agency run by people, right? And there's going to be a limitation in terms of workforce, in terms of man hours, in terms of, hands-on. So we do tend to see a dip in the processing of other types of cases as they focus on the H-1B cases. And we have to be understanding of these things. They're infallible, just like the rest of us, or not infallible, just like the rest of us, I should say.
So if I can put it in basketball terms, it sounds a little bit like trust the process, right?
Yes.
Stay on top of the news, do the best that you can to prepare, make sure everything is, at the best level it possibly can be, and then understand that it's going to be out of your hands as the government does what they need to do with it. So, yeah, I mean, it's nerve-wracking, but definitely good to know, right, that continuing to reach out, continuing to, spam might actually have negative effects on your case. Definitely something people may not have considered.
Yeah, absolutely.
So if you're just joining us, we have been speaking with attorney Alka Bahal on From Temporary Visa to Green Card, Long-Term Immigration Planning for Business Professionals. And now that we finished some of these initial interview questions, we are now going to move into our live Q&A session. This is your opportunity to ask questions directly to a licensed immigration attorney. Go ahead and drop those questions in the chat or call us live at 516-703-3483, and we'll take as many of them as possible. All right, so our first question is from Earl F. And Earl would like to know how long it usually takes to get a green card after perm has been filed by the employer.
So getting your permanent residency through perm labor certification is a 3-stage process, and how long it may be for you depends on a number of factors, including your country of birth being the main factor, and I'll explain why that is. The perm labor certification is just the first of 3 stages. Currently, the Department of Labor is reporting roughly around a year to process those, and you can look up that information online to get the latest processing times. Once the labor certification is certified, you then need to file an I-140 petition. This is an employer's petition to USCIS, and that can be done anytime, and it has to be done, in fact, within 6 months of labor certification issue before it expires. That can be done under regular processing or premium processing. I won't get into the pros and cons of that right now. The critical part to how long we might be looking at processing for permanent residency is this last piece, which is in order to file the third and final phase of either adjusting status in the US or processing your immigrant visa at a consulate abroad. That depends on when an immigrant visa number is available to you. This is determined by the preference category of your labor certification, which is typically either EB2 or EB3, and your country of birth. If you were born in a country that traditionally sends more individuals to the US than we have allocated visas for example, India and China, then you'll be waiting in a longer line than for people who were born in other countries, for example, Denmark. So if we are from a country such as Denmark, you're probably looking at an overall time frame of 3 to 4 years to go from 0 to permanent residency through perm labor certification. If you are from a backlogged country such as India, you could be looking at 12 to 15 years in EB2 or EB3 for 0 to green card.
All right, Earl, hopefully that gives you some insight. Just understanding that it really does depend on your specific circumstances and your specific cases. Hope that helped, Earl. And our next question is from Kimora Saunders. Kimora would like to know if she can apply for a green card if she's on a temporary visa, such as H-2B, which says she must go home soon.
So the answer is yes and no. So it depends on how you intend to apply for that green card. If you are able to apply as an immediate relative, for example, you marry a U.S. citizen, while you are in status on your H-2B visa, you're most likely going to be able to have your spouse sponsor you and file for adjustment of status while you're here. And that may allow you to stay here without having to go home. On the other hand, if you are looking to be sponsored by your employer or a family member who's not an immediate relative, they could file the initial piece for you, either the perm labor certification or the I-140, but it's not going to put you in a position to be able to file that last and final stage to adjust status prior to your H-2B expiring, since the H-2B is necessarily valid for less than a year. So that's not to say you couldn't pursue permanent labor certification on a separate but parallel track. So you're on your H-2B, they file your labor certification, you go home this year, you come back next year, and eventually you'll be able to get your permanent residency. That's an option. But solutions for coming on an H-2B and then being able to stay here and get permanent residency, unlikely to happen other than through an immediate relative.
Makes perfect sense. Kimora, hope that was helpful. And that brings us to our next question from Aisha. Aisha would like to know that if she changes jobs multiple times, will that affect her green card application?
So it depends. How do I put it? The fact that you changed employers frequently, so long as you maintain your non-immigrant visa status through all those changes, in and of itself is not going to affect your ability to get a green card. If you have changed positions post getting your labor certification and I-140 filed and approved by employer A, and you move to employer B, then you will need to have employer B do a new labor certification on I-140 for you in order to get your green card. You can't rely on the petitions approved for employer A while you're employed by employer B. So that could then affect your ability to get your green card or affect your application.
Absolutely. So making sure that you're, in contact with your employer, and to our previous point about staying prepared and staying proactive, just making sure that everything that needs to be filed is filed.
Correct.
All right. And after Aisha, we have our next question from Temilolua Badru, and they would like to know whether big companies sponsor green cards more often than small companies.
I'm afraid I don't have the statistics on that to answer that question from a data point, but I can tell you in my 30 years of practicing immigration law that both big and small companies do sponsor foreign national employees for non-immigrant visas and for green cards. Certainly there are certain specific, very large companies that are very well known for sponsoring foreign nationals, in tech, in finance, and that's sort of part and parcel of what they do, and they're known for it. Smaller companies, just because of their fact that they're smaller and just not as well known, certainly wouldn't have the reputation of being, known for sponsoring foreign nationals. But I have a number of smaller engineering firms or, chemical type companies where they need really highly educated individuals and really a specific profile, and they look worldwide regularly for their employees. And so may have, 10 to 12 out of their 30 employees that are foreign nationals. typically highly educated, highly credentialed individuals. So I don't know if that's more or less than a big company, but definitely small companies do sponsor people all the time.
Absolutely. A lot of it comes down to industry, like you said. It comes down to a variety of factors. So your personal case is really going to say more about how likely a big or small company is to sponsor you than just the broader scale at large.
Correct.
All right. Hope that was helpful. And our next question is from Damien Germanata, and he wants to know if he can get a green card without help from his employer.
There are ways to a path towards permanent residency without an employer's assistance. Either that involves sponsorship by a family member. In most cases, the U.S. immigration scheme is sponsorship driven. So either you're sponsored by your employer or you're sponsored by a family member. Outside of a sponsorship scenario, there are very limited options. There is self-sponsorship through national interest waiver or through outstanding ability, and that's really only available where you're really performing at an outstanding level in your profession. You have sort of a national or international level of reputation, or you've got the diversity lottery, which may not have the best chances, but it is not sponsorship driven.
All right. Hopefully that helps you out there, Damien. And our next question is from Ariana DiCaprio, who would like to know if the priority date is not yet current, can they still work or must they wait?
So the priority date relates to the permanent residency process. In that scenario, you are not given any sort of status or work authorization until you're able to file for permanent residency, which only happens when your priority date is current. If you are physically present in the US, then you need to be looking to your non-immigrant visa to see what are its terms and conditions, whether it allows you to work at this time or not. If you're here on a derivative H4 visa, for example, and your spouse is not in a position to give you H4 EAD, then you can be here and you can wait, but you can't work. If you're here as a student, there may be ways through school sponsorship for post-curricular or curricular OPT that you could work. But again, now it's going to depend specifically on your non-immigrant visa. What is it that allows you to be in the US? That's going to dictate your employment authorization ability.
Makes perfect sense. Ariana, hopefully that was helpful. And we'll just go ahead and wait for a second here to see if we have any other questions coming in from the community. All right, that's about all the time that we have here for the Q&A. If you have any other questions, feel free to ask them on immigrationquestion.com. And now, Attorney Bahal, just grab you for one more quick question before we wrap up here. As I'm sure you're aware, reports have shown that a federal judge has blocked President Trump's deployment of the National Guard to Portland. From an immigration and constitutional standpoint, how should immigrants, employers, and local communities interpret a ruling like this? And what does it reveal about the limits of federal authority versus state and judicial oversight in moments of heightened enforcement or unrest?
Great question, Nicola. So I really think that this particular scenario highlights what's been happening over the last 9 months or almost 12 months now, and the push and pull between the federal kind of push on immigration and the states looking for some level of autonomy. Now here we have really a federal judge issuing a federal court order relevant to a federal regulation about when and how the National Guard can be deployed. If I recall correctly, the order was that the National Guard could be federalized, that complied with what the requirements were, but that they could not be deployed because there was not enough of a demonstration of an insurrection or revolt or invasion, whatever the specific standard was. So I think Portland and the state of Oregon saw this as a win because it does say that the federal government can't step in on their autonomy by pushing the National Guard in there. But on the other hand, if you look at it purely from a legal perspective, this is, again, purely federal. It is a legal issue determined by a federal judge as to federal regulations. I think it is demonstrative of the current administration seeking to use any and every tool they can and really pushing it to its limits to try and address in its mind immigration in every which way it can. I mean, obviously the push here is enforcement. They want to enforce immigration laws the way that they want to enforce them, where they want to enforce them. So in the immigration community, among, I won't speak for every immigration attorney, but generally speaking, we saw this as a positive. We do think that states can police this type of an issue themselves. We think ICE is perfectly sufficient for, seeking foreign nationals that are not legally present in the U.S. The additional of the National Guard in terms of enforcing immigration laws, in my opinion, is highly unnecessary. So I'm pleased to see a federal judge actually applying and upholding the law rather than taking a political position. So I think all around it was a positive outcome.
Absolutely. Thank you so much, Alka, for your insights and for sharing your time and perspective today. Your insight here really brings clarity to a process that so often feels uncertain for professionals who are trying to balance their career growth alongside their long-term immigration goals. So hopefully this has been helpful for as many people as possible. To everyone watching, thank you so much for joining today's webinar. We hope this discussion helps you think more strategically about planning beyond the temporary visa. As always, you can visit immigrationquestion.com to ask immigration-related questions and stay informed about upcoming discussions. If you'd like to revisit today's session or share it with others who you think may benefit from it, the full replay is going to be available on Spotify soon. Just go ahead and search up Borderless Talk by immigrationquestion.com, and we should be right there. Join us again next week for another live conversation covering key immigration updates and practical guidance. Once more, thank you so much for your time today. And until next time, stay informed and stay connected. Bye, everyone.